Hi, everyone. Thank you for joining us in this lovely afternoon to attend this talk, this webinar regarding PIP strategies. I really appreciate you guys taking the time off to come and listen to this to get our latest updates regarding, especially I think you guys are here for updates regarding legal position when it comes to PIPs. Of course, as we go throughout this session, I hope that you guys are able to hear me. And if yes, please leave a comment in the chat box that's already available for you. And if you have any questions as well, please feel free to leave those questions in the chat box as well. And I hope that as we go through this session, you guys were able to obtain something that is beneficial, in especially for those who are HR practitioners or managers. You're able to understand a bit better how PIP works here in Malaysia, how is it structured, how is it done properly in the legal perspective, of course, to ultimately be able to mitigate any legal risks when it comes to managing employees. Okay, so um, our topic regarding PIP strategies, of course, the focus will be more on the recent legal cases in industrial court, where, just as a very brief background, whenever you have an employee who is underperforming, what these employees would usually face, of course, from the company would be that the company would have to set certain expectations as to whether or not these employees are satisfactorily performing their jobs in their respective job functions. Of course, when things don't go as well or as planned, because sometimes when you hire or recruit um, employees into the company, you might not know how they really are when it comes to performance. Therefore, there would be, in a way, some forms of trials and errors that come along when you are handling these employees, especially for HRs and managers. Okay, so um, of course, this then boils down to whether or not the company has proper policies in place in order to manage poor performance. Uh, and even if it doesn't have a policy in place, of course, we should still revert back to what and how the court perceives a proper PIP to be. Okay. So, of course, I've been mentioning PIP. So, PIP here would, of course, be the tool that is used to address poor performance issues for any employee who is poorly performing. And of course, um, the position has changed over the years. But then the core elements of what should be done when a PIP is conducted has not per se changed. So we'll go through several cases later to see how the court has observed whether or not companies were compliant when carrying out PIPs for employees who were not really performing. Okay. So again, like I mentioned, if you guys have any questions that pop up, midway when I'm explaining the cases, or uh, you know, uh, yeah, just feel free to leave it in the comment, and I will attend to those questions. I will try my best to address every single question as much as I possibly can, because 30 minutes is allocated for the Q&A session, and uh, there may be a repetition of certain questions, so I will of course, in a way, filter it to be able to answer the core question, the core question that everybody wants to know about. Okay. All right. So let's move on. So when it comes to PIP, I just want to give some general information regarding as to what it is. Okay. So, I mean, for some of you who don't know, or for some of you who are very new in the HR scenery, or as a manager, you're still very fresh. what is a PIP is it is essentially a tool that is used, by employers to address performance gaps. Performance gaps here meaning poor performance, especially if such performance is lacking during, for example, the appraisal assessment period, which of course can vary depending on the company, how the when and how and when the company appraises these employees. So it can either be on an annual basis, it can be a quarterly basis or a mid-year basis, or it can also be in instances where, for example, poor, poor performance issues that arise on an ad hoc basis. Those are situations where employers, be it managers or HR, and of course both parties usually would be involved. They must work hand in hand in order to ensure that these poor performance items are identified accurately and also addressed appropriately in the PIP. Okay. Okay, so who does it involve and where does it happen? Okay, so the PIP process, of course, is typically led by the employee's direct manager or supervisor, with guidance and oversight from the human resource department to ensure procedural compliance. And of course, it's usually conducted at the company's premises or where the employee is situated. Wherever they are, so it can be in branch locations, specific locations where the employee is supposed to perform, or it can also be situations where the employee, especially one that has to move around a lot, of course, they will be assessed at all the areas where they are supposed to be at. And this can be instance, for example, this can be employees who are designated to perhaps visit certain construction sites, to see and assess whether or not everything's in order, to supervise manual laborers in different construction sites. So that's just one example of where PIPs can happen. But of course, ultimately, how it is conducted, um, it really boils down to how the PIP is drafted and what performance items are identified as being unsatisfactory, especially during your one-to-one conversations between the HR or even the managers. Okay. Okay. Moving on to how it is conducted or how is it drafted. Okay, so generally PIPs, they are conducted based on company policy, and this is a very important point to note because there has been a trend in the court, and which we'll go through some cases later, whereby the court has been very reliant on company policies and for companies to actually follow through how they actually structure their poor performance management process. Okay, so in a way, in that sense, companies, it is very prudent for companies, I mean, especially for HRs and managers, to familiarize themselves with your own internal company policies when it comes to managing poor performance, if there is any policy lah. But if there is no policies, of course, we always revert back to what the courts have mentioned, because PIP isn't a matter that is addressed in the Employment Act. It is more of something that has been determined by the courts when it comes to how it should be conducted. And of course, the key word over here is it should be conducted in a manner that it genuinely assists the employee and is legally acceptable by the court in some areas, which of course include. So these I have really compiled a list of main points when it comes to what the courts look at when they want to assess whether a PIP is genuine. There are cases associated with each point, but I mean, for the purposes of not making these slides too long, I did not include it in. But essentially, of course, there must be documentation of poor performance in a yearly, mid-year, or quarterly appraisal, and is conducted that identifies the performance gaps. Of course, this is a very standard. I mean, every company has this. Okay, and then, of course, secondly, a warning on poor performance and the actual PIP must be issued regarding the performance gaps, and items are indicated as precisely as possible uh, by using, of course, the guiding principles of the SMART principle lah. I don't really want to go into that too detailed because again, our main focus here is looking into case law. Okay, as a guiding method. And thirdly, the period of time given for the PIP to for the PIP to be satisfied in a manner is, of course, a reasonable period of time and or opportunity is given to improve on such PIP items or goals. So reasonable period of time here, the court has not actually, there has not been any specific case law to say that, how much time you must give for a PIP to be carried out. But generally, the acceptable period of time, as in industry practice that we've seen in many, many different companies, and we've also assisted in those companies as well, would be, a minimum of 3 months, with any extensions if the company or the business or the manager feels that there can be more improvement to be done with the additional time given. Okay. So, and fourthly, of course, employees' failure to achieve PIP goals will allow the company to impose punishments up to termination of employment, depending on severity of the failure. Okay, this is an important point to note as well, because when we first issue out the warning on poor performance and the actual PIP, of course, indications of the employee being able to be terminated if they don't fulfill the requirements of the PIP should also be indicated inside the letter that's sent to them or notification sent to them. But of course, there are instances which have very recently been decided where, although the company has the right to assess the passing or failing rate, uh, when employees, of course, the law being very pro employees, it would ultimately depend on the employee whether or not they feel that the PIPs carried out or even the failure or passing rate is unreasonable for them in their position. And when that goes to the court, sometimes the court would intervene to say that it's not fair for them because maybe in the past they've been doing very well. All this time, all the conversations that the employee has with the employer has always been a positive, in a positive manner. There's always been improvement. It's just that they didn't reach the targets, perhaps at maybe an unreasonable target that is set in the PIP, and because of that, they are punished for not being able to reach that threshold. Okay, but as a matter of fact, maybe there are certain items that have already shown improvement, though did not reach the threshold, but the courts the courts are very, in a way, very slow to dismiss any forms of how the companies assess whether or not there is, a pass or a failure lah. Okay, so that's something very important to note, which is, of course, every failure of every PIP does not necessarily lead to termination, depending on the severity. Okay. And severity here, I think one of the major things to also take note is whether or not the PIP items or even the assessment and appraisal that was conducted, the main functions or the core responsibilities of the employees were actually affected in that sense, and also affecting the business. So that's something also you may want to consider, or managers and HRs to consider, whether or not you want to pass or fail the employee, or whether or not those items should even be in the PIP, should even be in the PIP to begin with. Okay. And then moving on to the fifth point, of course, would be a relapse in poor performance. Okay, should entail another PIP. I saw in the comments there were a few questions regarding whether or not another PIP should be conducted if there's a relapse in poor performance. So the legal position now is that yes, you should still conduct a PIP if there's a relapse in poor performance, and this can be in very frustrating situations. Like, for example, you just put an employee on a PIP and then they pass their PIP, for example, after 3 months, but then suddenly the month immediately they relapse in their performance. So the court has always been in a position where once there's a relapse or even an immediate relapse in performance, another PIP should be conducted. Okay. And if not conducted, it can attract some form of condonation, depending on how long the delay is taken in addressing those PIP items, those poor performance items. Okay. However, I mean, that being said, I have seen companies we've worked with some companies where they have policies that say that, and clearly indicate that um, certain PIP items, especially ones that relapse, they have clearly informed their employees that if there's a relapse in the performance, for example, in the next 6 months from the date of the PIP passing, then of course the employee may be liable for termination for that in that sense, because for example, for some companies who are very fast-paced moving, um, there would be instances where, for example, the KPI changes very frequently, and in that sense, PIPs may occur very frequently as well. So, in order to prevent especially wasting of time in addressing these kind of poor performance issues by initiating that kind of processes, there are some companies who've just implemented that type of policy to basically say that, if there's a relapse in poor performance, we are not going to put you on another PIP. We're just going to consider that, we will consider termination in those instances. But of course, that hasn't been something that has been tried and tested in court. And I view that if something like that does get tried and tested in court, it might not hold up completely, because number one, the courts have always been in the position where if there's a relapse in poor performance, the PIP should always be conducted again. Okay. Okay, so moving on to the next point, PIPs should not be used as an exit tool for employees. I think this is very clear cut. Has been an abundance of cases that talks about this situation, especially in situations where certain PIPs especially in situations where PIP is not necessarily to be conducted. For example, where there is a probationer, PIPs are not necessarily needed to be conducted for probationers, and also for senior employees. But that being said, it's also industry practice to put those probationers and senior employees on a PIP if it's necessary, if the company deems it necessary. However, it always goes back to the principle that the PIP should be made genuinely and done genuinely, and not for the purposes of getting rid of the employee. Okay. And then moving on to the last point, which is, of course, burden of proof of proving poor performance is on the company to prove that the employee is not performing. It is not for the employee to say that they are or they are not poorly performing. Okay, that has never been the position of the court. Okay, so whenever these things go to court, for example, or even to the IR department, it is always incumbent and it is always on the part of the company to show that this employee did not fulfill, their core responsibilities, the performance items that they are required in the core responsibilities. Okay. Okay, I see a lot of questions coming in. I'll take those questions later lah. So I hope you guys will be patient with me. Okay, so now that we've covered the very basics and general principles of a PIP, and I hope everybody has a very clear vision of how PIP works now. So we will now look into how the court has seen whether or not PIPs were conducted genuinely or with bad intention. Of course, bad intention here would be with the perception or with the intention to get rid of the employee lah. Okay, so it can be in many situations, and let's just go through one by one. Okay. So the first case, so these are all very recent cases, so they're fresh out of the court, mostly industrial court cases. The recent cases have not gone to High Court or Court of Appeal or even Federal Court because, like I said, it's still quite fresh. So this is the position that has been taken by the IR court as of now, lah. Okay, but the position may change in the future depending on whether or not there's any appeal, especially for a judicial review in the High Court later on. Okay. So in the first case, so Nadira Othman and True Pristine. So in this case, the employee was dismissed for alleged misconduct and poor performance. Okay, so of course the key legal issues here were whether performance and or absenteeism were established as just cause for dismissal. So here it was a situation where the company associated absenteeism as a part of the employee's poor performance, because I think this is something very common. where if, of course, the employee is absent from their duties, they will entail, to a certain extent, poor performance because they're not around to perform their duties. Okay, so here the claimant has been on a prolonged medical leave due to IVF fertility treatment. And of course, there was no evidence that the employer rejected this leave request. In fact, the leave appeared to have been approved. Despite this, the company alleged that the claimant's performance during her tenure was unsatisfactory, describing her as irresponsible and as well as negligent during in performing her duties. So a warning letter was still issued, citing poor performance and misconduct lah, in these circumstances. Okay, so to delve in further, of course, when the court looked at all the evidence, the court deemed that the company had failed to implement a performance improvement plan or to provide any appraisal reports to show that the claimant was given a structured opportunity to improve her performance. So the company here is like claiming, a lot of things, saying that, oh, it's poor performance, it's misconduct, but they never actually initiated any, poor performance or PIP process, be it in accordance to its policy or otherwise. Okay, so in a way, the company is kind of contradicting itself, and it kind of bypassed the entire process. So this is a very clear example of bypassing the entire process. So the court emphasized that in dismissal cases based on poor performance, an employer must show evidence of proper evaluation, communication of performance deficiencies, and opportunities for improvement. Okay, so all those things I've mentioned earlier. So without a PIP or even a performance assessment, the company, was unable to demonstrate that it had followed fair procedures or that dismissal was substantively justified. Okay, of course, here the court, taking all the evidence into consideration, they held that the employer had failed to prove poor performance. Consequently, the dismissal was found to be without just cause or excuse, and of course, the court awarded the claimant the appropriate awards, which is compensation in lieu of reinstatement and also 12 months back wages amounting to 90K lah. Okay. One more thing to note here before I move on, just going back a bit, when it comes to, because here the employer was also citing misconduct issues. Okay, so misconduct here would be this employee taking maybe excessive paid sick leave. Okay, but the problem is, like the court said here, the employer themselves did not actually reject the leave request, and all the documentation points to the fact that they actually allowed it. So if the company were to go on the issue of misconduct as well, it wouldn't be appropriate, especially since now the court has actually said that there isn't even any documentation to show that they rejected it. Okay. Okay, moving on to the next case. So in the case of Firuz and Emery Oleochemicals, so in this case, the court scrutinized the PIP process that was implemented by the company and found significant procedural flaws and elements of bad faith in the entire process lah. So a few points I would like to point out here in this case. Number one, there was an improper extension of PIP that was found by the court. So here, the extension of the PIP period to 6 months was deemed unwarranted, as the company's own SOP or policy allowed up to 8 months. The clause that they cited the clause in the policy is 5.6.11. So, however, the manner in which the extension was communicated to the employee was found to be misleading, potentially undermining his confidence in improving his performance. And of course, the court viewed this with suspicion, noting the emergence of bad faith in the PIP process lah. So some things to note here would be, number one, when it comes to extension period, right? There is no, to put it very clearly to you guys, there is no case law to say that an extension of PIP must be for this specific period. No such thing. But if the company specifically states in their policy how much of extension would be given when it comes to PIP, that is when it gets a little bit more sensitive, because you've already put something in writing in your policies to say that you are going to do this. But if you don't follow it, then of course the court would view it as, you're not even following your own policy. So when it comes to drafting, this is a separate issue. So when it comes to drafting poor performance policies or even performance management process policies, I would usually recommend that, when it comes to extension of poor performance or PIP period, try to word it in a way that it is quite uh, broad or general as possible, but it should also be worded in a way where it should be stated that a reasonable period of extension would be given. So this doesn't necessarily mean maybe for a period of 8 months or maybe a period of 1 month or 3 months. It really depends on how complex is the PIP items. That's number one. Number two is how long does it actually take for you to actually see the results from the PIP items that you have placed in the employee's PIP. Okay. Because sometimes maybe 3 months is not enough. I've seen PIPs where, for example, the KPI for maybe 1 month of PIP is like 3 million. I mean, obviously that's not achievable, and it's a bit ridiculous unless and until it is proven by the company that maybe there is some benchmark, maybe there have been employees in the past, in that similar role, who were able to achieve that form of KPI within such a short period of time. Okay, but even if that were the case, that benchmark I think would be quite high because um, it really depends on how reasonable it is lah. Okay, and also a lot of factors might also be involved. For example, market conditions, uh, you know, yeah, market conditions. For example, if it's regarding, for example, sales. Okay, okay, and then there are also other things that the court also brought up, which is the second one would be erroneous inclusion of absenteeism in assessment. Okay, I want to focus a bit more on this because I realize that whenever we have clients asking us about, whether or not we should put behavior in PIP, to a certain extent, yes, and to a certain extent, no. Okay, so here the court has clearly stated that here, okay, for example, the employee's medical and unpaid leave totaling to 48 days were wrongly factored into his performance evaluation under objective paribadi in the performance document, affecting his rating unfairly. Although his punctuality was recorded at 95.88% and rated 3/4, his absenteeism was used to justify a low rating of 1/4 without proper grounds. Okay, so here is a very interesting example of how the company assesses its passing and failing rate. Okay, it didn't you realize that the PIP here didn't really touch on his core responsibilities. It touched more towards his behavior, but then the punctuality itself was inconsistent with how the company evaluated what amounts to a pass or what can reasonably amount to a pass. Okay, so here the court said, I mean, it doesn't make sense because they said that the company wants to justify his termination based on absenteeism, and even if it wanted to justify, termination based on absenteeism, they should have, in my opinion, they should have used the disciplinary route instead, which is effectively, issuing a show cause letter, asking the employee to explain why he was absent, which then leads us to this third point over here, which is absence of due process for alleged absenteeism. Okay, so of course, while it is accepted that excessive leave, even within entitlement, may amount to misconduct, the claimant was never charged with such misconduct. That's the problem here. Okay, so there was no show cause letter or domestic inquiry initiated regarding absenteeism, yet it was used retrospectively as a reason for dismissal. So, of course, the court found this to be a violation of due process because something that should have been classified as a misconduct was wrongly mixed into the performance management process. And of course, this has been a position in the court from the courts from way beyond, whereby these two processes should not be mixed at all. Okay, misconduct is misconduct, things that have to do with behavior, whereas performance is performance. Most of the time, relating to the core responsibilities of the employee. Okay. So, as a conclusion, the court concluded here that, of course, obviously there was bad faith. The PIP was not genuine tool for improvement, but it was instead used within the pretext to justify dismissal. So it reflected oppression, bad faith, and ulterior motives on the part of the employer, lah. Okay, as we have clearly seen. Okay, so the key takeaway here would be, of course, employers must administer PAPs fairly, transparently, and in accordance with proper procedures. Okay, it's something to bear in mind. Very important to bear in mind, especially for HR practitioners. So you guys are also, as HR practitioners, you are responsible for advising managers on how they should conduct their PIPs appropriately, how the PIP goals should be formulated in a way that is you know in a way used to help the employees, not seen as something that is very impossible to achieve. Okay. And of course, performance assessments here must not be tainted by unrelated issues such as absenteeism, unless such issues are properly investigated through due process. Okay. Failure to do so may render the dismissal unjust and legally unsustainable. Okay. Okay, moving on to the next case. Okay, so in the case of Ahmad Razif, okay, so this case, it concerns a very interesting situation where this case concerns constructive dismissal and also a mixture of poor performance, okay, whereby the employee here alleged that the company's actions amounted to a fundamental breach of employment contract, leaving him no choice but to resign. Of course, I mean that as an introduction, I mean, constructive dismissal is basically a situation where the employer, which is the company, breaches their side of the contract in um, allowing the employee to do their duties lah. Okay, so this can be situations where they don't allow the employee to do their job properly by putting them in very difficult situations or difficult positions, or even transferring them to a role that they've never been in before. Okay, so this case emphasizes on that, and let's just go through and see the facts of the case. So in this case, uh, of course, I mean, in July 2018, so during a mid-year assessment, as you can see here, in July 2018, and now the case is in 2025, so it takes a while. Okay, just to bear in mind that IR court cases can go on for a while, depending on when it's filed. Okay, so in July 2018, during a mid-year assessment, the claimant was accused of improper behavior during a crisis management exercise. He claimed that this was a pretext to justify a lower performance evaluation. Okay, so a formal reminder was issued on in the same year in August, which is a month later, and a warning that failure to improve could lead to a performance improvement plan. And then subsequently, of course, a 3-month PIP was implemented from October the same year till January. Yeah. So during the PIP, the employee actually received 2 warning letters within 2 days, which was somewhere nearing the end of the 3rd month. Okay. One letter cited sleeping at his death, despite him being diagnosed for a medical condition, which is sleep apnea, and the other cited poor performance and insubordination. Okay, so again, another example of how misconduct is lumped together with PIP. Okay, so here the employee contended that the PIP was designed to ensure his failure, uh, and that the company failed to provide coaching or support. He cited factors like excessive workload, lack of manpower, workplace stress contributing to oppressive work environment. Okay. So that being said, there were certain instances inside this case where it was very detrimental to the company, and those uh, very important points would be here. Okay, so here this employee, he objected repeatedly to being assigned to a to the health, safety, and security portfolio, for which he was unqualified. Yet the company took no remedial action in addressing that situation or even putting him in that situation. They didn't even give him any training. They didn't even do anything. They just put him in that position. They just transferred him to that position. Then naturally, because the employee being in a position where he cannot perform, he then resigned in before the PIP finished by giving 3 months notice, and the company opted for an early release with payment in lieu of notice, ending his employment on 31st December, which was, I mean, clearly before the PIP finished lah. Okay, so the court's finding here was that improper warning letters, despite medical evidence, right? The court found that the company was aware of the employee's whole situation of having medical condition, but it still issued 2 warning letters without revisiting or even retracting them. Okay, this, of course, this what should have been done, of course, when the company wants to address medical conditions would be, of course, to send the employee to a, a doctor or even a specialist to ascertain whether that condition will greatly affect the duties of the employee, and perhaps maybe consider, even termination based on medical grounds. But that was not appropriately done, and of course, this conduct by the company was inconsistent and not genuine, and revealed that they had likely predetermined to remove him lah. Okay, so they were just harping on all of these points, but they were not actually doing anything about it. Okay, or not using the proper processes to address the situation. Okay, so another thing that the court also pointed out was breach of mutual trust and confidence. So here, the employee consistently raised valid objections about his assignment to a role he was unqualified for. Okay, so this is very fair for an employee. Uh, if I were to put myself in the shoes of an employee as well, uh, unless the company has very solid reasons as to why they require the employee to be in that position, okay, usually would be a situation where, if, for example, if that transfer was a genuine transfer, they intended for that person to be in that position because maybe due of lack of manpower. But even in those situations where the transfer is necessitated, I mean, taking a step further to help the employee would be, of course, to employ different trainings to help him in that position so that he's able to perform. Okay. And then, of course, the company's failure to act on his concerns or support him, of course, constituted a breach of mutual trust and confidence, which required, in this, which was required in an employment relationship, rendering the work environment, of course, intolerable. Okay. So in that sense, the company is kind of seen to have been like chasing out the employee, and then because the employee couldn't take it anymore, that's why they filed a constructive dismissal lah. Okay, so something to bear in mind again here. The takeaway is that poor performance, putting employees on poor performance, can in a way also drive them out, and in a way allow them to file for a constructive dismissal if the PIP was not conducted properly. Okay, that's always the key point here. Okay, I hope everybody is able to catch that. Okay, so the court's findings are, sorry, this is the third point that the court observed, where constructive dismissal was proven. So here the court held that the claimant's resignation was not voluntary, but was caused by the employer's conduct, amounting to a fundamental breach in contract. And of course, the dismissal was without just cause and excuse, and the employee was awarded back wages and compensation in lieu of restatement lah. Okay. Okay. I want to talk about this case also. This case is a situation where this employee, which is Lim Fang Sin, brought an action against this Australian Trade and Investment Commission lah. So I think I was informed that there are some Australian, do have some Australian friends here who have joined our talk. Maybe this is something that you guys can take note as well. But essentially, I thought this was a very interesting case to talk about because this was a PIP failure termination that was made on a hearsay basis. Okay. And to the court, that is a big no-no lah. Okay, that is a big no-no because it was a situation. Before we go into the details of this case, the termination was essentially made by a person who was not even overseeing the PIP. Okay, that's why it was hearsay. Okay, and there's been abundant of cases in the court to say that hearsay, termination is not rightful termination, especially if the person who is calling the shots does not know what is going on. Okay, and they are just informed that, oh, this person just didn't pass. So that itself is something that is very dangerous, and of course will attract legal risk lah, in that sense. Okay, so let's go through it in detail. So the employee here was placed on PIP late 2019 due to alleged poor performance. After the employee contested the claims and demonstrated improvement, then the company then extended the PIP for another 3 more months in 2020, which effectively delaying any termination decision lah. And of course, there were multiple appraisal reports during this period, which consistently showed that the employee was a good performer and also was awarded for her efforts in doing, in performing her duties, essentially. So the court found comprehensive evidence of the employee's strong performance, including positive feedback from colleagues and supervisors, and no indication of dissatisfaction. So the company's decision to dismiss was, based mainly on hearsay, of which the court deemed improper and against fair dismissal principles. Okay, so ultimately the court held that the company failed to improve poor performance on the balance of probabilities. Uh, okay, and in accordance to this provision. Okay, so this is a situation where, um, just to elaborate further, I didn't put it here because the case was quite lengthy, but essentially the person, the witness that was called, which is the person who terminated the employee based on the PIP results, was a manager who was overseeing the entire team from Australia. Okay, but this manager didn't know what was going on. Okay, but he was aware that a PIP was commenced, but didn't know of the details of the PIP and whatnot. He just knew the results, and then he put the trigger in that sense. And of course, the court, they referred to section 114 of the Evidence Act, 114 sub G, which says that of course when it comes to hearsay, it's something that cannot be done lah. Okay. Okay, moving on to the next case, Engku Aznita, so SME Bank. So here, this is also a very interesting case because the person that was terminated was a HR in the bank. Okay, so I mean, you guys as HRs, you guys are not, you're not immune to the PIP process lah. Okay, so she was suspended pending an investigation following a complaint. So her suspension was lifted while the investigation continued. So during this period, she received an unsatisfactory performance rating and was placed on a 3 months performance on 3 months PIP, which was later extended for another 3 months. So here, the employee, also very similar to the previous case that we talked about, she resigned. She alleged constructive dismissal, claiming that the bank breached her contract by extending the PIP and failing to formally close the investigation. Okay. So the key legal findings here was that the court actually applied the contract test for dismissal. So here was more, I mean, the court actually looked more towards the constructive dismissal principles. Contract test here meaning to say that the court looked into whether or not the company had fundamentally breached their terms with the employee. And and of course, the court also held that extending the PIP to give the employee more time to improve actually lacked, any formal closure of investigation, but it did not constitute a breach of contract justifying resignation lah. Okay, and here the claimant actually failed to prove constructive dismissal on the balance of probabilities because evidence showed that her resignation was voluntary, motivated by the desire to avoid disciplinary action without coercion or duress lah. Okay, so I mean, this is a case where the company kind of won, whereby based on the facts of the case and all the documents that were presented, the court actually said that this employee did not actually constructively dismiss herself, be it on a PIP or be it on a misconduct basis, because even in the letter itself, it didn't show that she was forced to resign or the company had done certain actions that caused her to resign. So that's something to bear in mind lah. Okay. Okay. This case. Okay. So this case, I think in this case, some of you guys might know about because it kind of blew up for a bit somewhere earlier this year. So this is the case of Tung Yok Leng and Maxis Broadband. So this is a example of a case where the company had actually dismissed or terminated an employee for poor performance based on a passing and failing rate that was not reasonable lah. Okay. So if we look into this case, the employee was employed for 25 years and she was last holding a senior management role. She was placed on a PIP due to alleged poor performance. However, she still failed. She failed the first 3 reviews, but met all targets in the 4th review. Despite this, she was terminated. The employee actually argued that the PIP process was unfair, lacking in proper guidance and coaching, and that she was burdened with additional duties of training inexperienced staff while meeting her own targets. Okay, so this one, as you can see here, this is also again a classic example of a badly drafted PIP lah. Okay, which doesn't follow per se the SMART principles, and because of that, again, these kind of situations would usually escalate to court lah. Okay, so what the court found here was that the court found it was unreasonable and, of course, bad faith on the part of the company to continue the PIP after the employee had met all the goals at the fourth review lah. So she should have been removed from the PIP then, and the extension was not a gesture of goodwill, but it indicated bad faith conduct lah. So since the employee had 25 years of experience of service without prior warnings, termination for performance without proper prior notice or documented coaching was definitely unjustified. And the company also failed to provide any evidence of any meaningful coaching or support during the PIP. Okay. So one of the things the court looked into here was again 25 years of service, which is a long time. There was no downward trend. The trend was upwards. The trend was also not in a yo-yo sense. Okay, so when we want to consider placing employees on PIP as well, I think it's also very prudent to, see whether or not there's a downward trend, there's an upward trend, or yo-yo trend lah. Okay, before we put an employee on PIP. Okay. Otherwise, when we do put the employee on PIP, which is usually for the period of assessment that they were placed on, if it's something that has happened very recently, it's always very important to find out as to why there's suddenly a sudden drop in such performance lah. Because again, we might not know what's going on with the employee. Okay, their performance might be affected by maybe certain personal things. Because all this while they've been doing fine. So I think it's always very important as a HR, because you guys are responsible for, putting the bridge for the for the company and the employees, being the bridge for the companies and employees. That is where you have to be able to know what is going on, and in that sense, also in a way help the employee to, figure things out lah. And also the manager as well. Okay. Further, okay, in this case also assigning the employee additional responsibilities to coach inexperienced staff while expecting her to meet her own KPIs was unreasonable and undermined her ability to improve. So the termination was therefore found to be without just cause or excuse and not made in good faith. Okay, I think another thing to note here from what we can see, what the court explained, is that whenever we have already initiated a PIP, okay, we already laid down maybe 10 items or even 7 items. Based on whatever they were assessed on, it is always important to only stick to those performance items during the period that you have stipulated. Because sometimes when we go through a performance improvement plan, there may be certain things that come up in between. Okay. And then more often than not, I have seen managers and even HRs who want to add on to the PIP that's already in place. Again, that's a big no-no, because those are things that arise during the PIP. So if you want to address those additional PIP items, you should start another PIP in order to address those additional items and not add it on. Because again, when we talk about timeline, reasonable opportunity, is the additional, naturally sometimes and more often than not, the additional item or additional poor performance would have to have a separate period in order for you to see results. Okay, unless if the PIP has not commenced yet and you identify certain additional PIP items you want to add on, yes, you can still revise the original PIP, add on the new PIP, but reset the period of the PIP commencement period. Don't continue it on. Okay, so reset it. I think that's something very important lah. Okay. Okay, moving on to I think this is the last case. Yes. So this is the last case that we'll talk about. Okay, so in this case, Alfian Effendi Ahmad Anwar. So in this case, the employee was a mechanical engineer, was placed on a 6 months per PIP after being rated according to the company's rating for needs improvement. He successfully met the company's PIP requirement of a rating of 3, which was acknowledged by the HR. However, despite this, the company extended the PIP for another 3 months, which raised objectives and subsequently terminated his employment on grounds of poor performance. You see, like I mentioned earlier, if you have something, if you have certain things you want to add on, if you want to extend certain things, try to make it a little bit more realistic when it comes to how the employee can achieve it and whether or not it's achievable within that period. Okay. So the key legal point here is that the company fulfilled the first two limbs of here the Eureka construction test warning is basically the employee was given. The employee. Sorry, to elaborate the Eureka construction test warning, I already mentioned it in the first part of this entire session, which is basically warning must be given to a poor performer. Reasonable opportunity must be given to the poor performer in the PIP, and even they were warned and given the chance to do the PIP, they still failed to reach. They still failed to achieve those PIP goals. That is the three limbs, lah. Okay. The court assessed those limbs and basically said that the company actually failed the crucial third limb because the employee actually improved and met the PIP's initial objective. Okay. So the company had actually acted unreasonably by extending the PIP with increased targets after the employee had met the original PIP goals, effectively setting him up to fail the extended PIP. Okay. So this was a situation where the employee actually passed the PIP, but the company, of course, in this situation would be probably a situation where they just want to get rid of him. They unfairly extended it and terminated him based on the extended period with increased, goals. So of course, naturally, the company's termination of the employee was without just cause and excuse, lah. Okay. Okay. So we're now moving towards the end. I would just like to touch on some common questions that I've very often received from my clients regards to how do we handle PIPs. Okay, so these were three questions which I hope will help you guys to understand a bit better. Okay, question one. Before I move on to the Q&A session, lah. Okay, can an employee still receive incentive or bonus payments while on a PIP, or would that send a conflicting message? Okay, so my answer to this has always been it really depends on what type of incentive this is and whether it is paid conditional upon the employee fulfilling the conditions stipulated inside. Okay, it is very important and prudent to see whether through what period is the assessment period of the incentive done for, because it may not actually correlate to the present action of the PIP. Because if the employee had actually satisfied the performance requirements during the incentive period, it technically doesn't relate to the PIP, and usually you treat the PIP as an isolated incident lah. And then usually when it comes to the payout and everything, I would usually advise to say that this is nothing to do with the current PIP that they're on. This is a payment that is based on the current policies that are in place. Okay. Question two. So I have an employee who refuses to agree with the PIP. What should I do? Okay. I think I saw one or two questions regarding this. Basically, non-compliance with the PIP. Employees are not cooperative during the PIP period. General rule is that PIPs are imposed unilaterally by the company. Therefore, it is initiated based on an agreement of the. It is not per se initiated. Sorry, I think there's an amendment there. It is not initiated based on the agreement of the employee on the same, unless the PIP was tainted with bad faith lah. Okay, so the employee refuses to participate in any conversation regarding PIP and or to participate in the PIP as a whole, it can be deemed as a misconduct of insubordination, which can be subjected to termination. And there is this case here to say that lah. But one thing to note when it comes to insubordination of PIP is whether or not this PIP was disputed by the employee as being a genuine PIP to begin with. Because like I said, not every PIP is drafted in a very good manner for the employee to understand or even feel that they can even achieve it. Okay, so if the employee feels that there is a valid reason or a valid ground that the PIP is not something that he can do, I mean, what usually happens is that the employee may indicate at the bottom of the letter to say that they object, they accept the PIP but under protest. Okay, so when those cases actually go to higher court, the court will actually look into, you know, that the employee still went with along with the PIP, but they didn't agree as to why or how intense the PIP would be. Okay, but they still followed, perhaps with the fear of not being able to, not, or with the fear of their actions amounting to insubordination lah. Okay, so there have been one case in the past in 2023. I mean, I didn't put it here, but that is essentially the position of the court. Not every single PIP is also valid. We must draft it properly. Okay, and such PIPs can be contended in court lah. Okay, and the last question. Okay, how do I fail or pass an employee under a PIP? And if the employee fails, is termination always possible? Okay, this is the most common question I've gotten from every single client that I've encountered. So factors to take into consideration, of course, is how does the company assess the fail and pass rate? As we already looked through the number of cases that we already talked about, we need to be able to determine what is a reasonable pass and fail rate lah. Okay, we can't take certain passing rates or failure rates. For example, majority of the passing or failing rate is based on, for example, absenteeism in one of the cases that we talked about just now. So essentially, we should not consider immediately dismissing the employee if there has been significant improvements seen during the PIP. And of course, company or even managers may consider extending the PIP for further reasonable period to assess the performance lah. Okay. All right. So that is essentially it. So now we'll move on to the Q&A session. This is the end of the whatever that I want to share about. So we will now move on. Okay. So, but before I move into the Q&A session, right, guys, I'll just like to talk about a few things. Number one, I think on the screen you can see that we have a WhatsApp group. You can scan the QR code to join our channel to stay updated on webinars like this, that you can register for, and for us, and we periodically send updates regarding circulars or even updates regarding the law through this WhatsApp channel. So please, if you are interested and want to know more, even regarding our services, please feel free to scan the WhatsApp, the QR code, which leads you to the WhatsApp channel. Okay. When you do reach the WhatsApp channel, it's very important for you to click follow and also click the bell on the top right for notifications to be on, so you'll be alerted through whatever device that you've added our channel to lah. Okay. And then another thing, before I move on to the Q&A session that I'd like to share would be our upcoming public courses. I think if you are HR practitioner or even managers who are interested to know more of how, or in depth of how do we handle, for example, termination situations, and how do we legally terminate employees for misconduct, there is an upcoming public course which we will later put out as a brochure, as a flyer, so you guys will have more information regarding that. Please do note that, this is actually our first ever public course, and we're also conducting another one in JB and Penang, but that would be more towards a program more for people managers, and it is not only restricted for HR only. So of course, if you are a newly promoted people or managers, supervisors handling a larger operations team, it will be perfect for you. So this public course in JB and Penang, it will focus on HR toolkits for people managers lah. Okay. So now let's move on to the comments and the questions. I believe I've answered some on the way. So please do bear with me, guys. Okay, moving on to the first question. So if the company set the performance recovery period as 3 months, could the employer terminate the employee immediately after 3 months PIP without serving additional notice period if the employee failed to achieve the important improvement targets with proper proof documented? Okay, this is by Miss Suki. So here, essentially to answer this question, no, you cannot immediately uh, terminate the employee after they failed the PIP period. You must either still let them serve the period out, or if you want to waive the period, you want to let them go, you need to pay in lieu lah. Okay, pay in lieu of the if, like, saying for example, they notice 3 months, you pay them in lieu of 3 months. That sense, you are waiving your right to notice, and also, rightfully paying out the employee lah. I mean, on this point, actually, when it comes to waiver of notice period in Section 12 Sub 2 Proviso of the Employment Act, it actually states that the company actually doesn't need to pay in lieu if it waives its right to notice period. But we have seen the Labour Department being very stern in their position with this, whereby although the company may waive the notice period because the right of notice period actually belongs to the company, the Labour Department still is of the position that they should still pay the notice period. So to be safe, and of course to not attract any labour complaints, we would usually recommend to just pay in lieu. Okay. Moving on to the next question. I hope that I've answered that question. So what is the minimum requirement of period or for PIP, and what is the main criteria that needs to be measured? This is by Aquila. So I think I already talked about this earlier. There is no fixed minimum requirement period. Industry practice has always been 3 months, but it can be more than that, depending on how much time is needed for the employee to show results in that position, be it a new position or a newly transferred position. And of course, the main criteria would be related to, more often than not, the core responsibilities and core duties of the employees. It may be behavioral issues affecting performance, but that shouldn't be the bulk of the passing rate or failure rate, as we've seen through all the cases. Okay, all right. I hope that answers that question. And at what point during the probation period should we begin to measure an employee's performance? And is it appropriate to implement a PIP while they are still on probation? This is by Anis. What point of probation period? From the start of the probation period, you should communicate what is expected of the probationer from the very start when they first enter. What is expected of them? What will be assessed throughout the first 3 months or first 6 months of their probation? And whether or not you choose to implement a PIP after a certain period, which I would usually recommend maybe slightly before the end of their probation period, you can still conduct a PIP. However, the law has been of the position where if you have conducted the proper appraisals during the probation period, which is supported by documentation, there is actually no need to go through a PIP. Okay. But that being said, if that wasn't done, we would usually tell clients to extend the PIP for maybe 1 to 3 months and properly documentate that performance within such month. Okay, to basically assess whether or not you want to confirm the employee lah. That can be in official PIP, or it doesn't necessarily have to be in a PIP. But if you want to use a PIP to address that situation where you don't have proper documentation, you can. But again, we go back to the principle of whether or not the PIP is conducted genuinely, and you have to follow the principles of how do we properly draft the PIP, using the SMART principles lah. Okay, so I hope I've answered that question. So does HR have to monitor the target setting by the supervisors in the PIP form, and how HR can understand if the target is achievable? The comprehensive workflow for the PIP process. So this is by Nadira. So here, I wouldn't say HR is per se required to monitor the target setting closely by the supervisors. HR's role here would be more towards understanding what the employees are supposed to do, okay? Because ultimately it relates to the business needs. Be it because you are in a position of a HR, you also need to know how the business works, especially if you are a HRBP or a HR manager lah, okay? So you need to know how it works, because when uh, the managers would be the key persons overseeing the PIP, because they would know what the employees are supposed to achieve and whatnot. Your role is, of course, to be able to tell the managers that whether or not these things are allowable under the law, especially like, for example, if certain items may seem to be unachievable, or may seem to be uh, certain items where require training or even coaching. So those things you would have to tell the manager to say, look, we need to all do all this in order to cover all our bases. And also, of course, to tell the manager to document every single thing that goes on with the PIP. Okay, be it internal reviews, one-to-ones, communications. That's even the weekly meetups. Uh, so that's the role of HR essentially in the whole PIP process. And of course, the important one will also be to familiarize yourself with the PIP policies in order to know how the process flow is like. Because again, we don't want to bypass. We don't want it to be a situation where we bypass the process like we saw in the previous case just now, whereby company promised 8 months of extension, but you only give like 6 months or even 3 months. Not appropriate, doesn't comply with the policy. And if you advise otherwise, then essentially you're not fulfilling your role as a HR lah. Okay, next. Um, hold on, I think we skipped the question here, but I think I might have answered this question. Just give it a read. Okay, never mind. So can an employee refuse to sign the PIP letter if without employee's signature, does the PIP process still valid? So Rachel, I think I already answered your question earlier. So basically, if the employee does not want to cooperate or does not want to sign the PIP letter, technically it amounts to insubordination. But again, we also need to go back to the fact of and assess whether or not the PIP has properly been drafted in order to initiate this action of insubordination lah. Because if the PIP has properly been drafted, we've covered all bases to ensure that this employee really did not perform and all the PIP items are reasonable, then we can proceed with the disciplinary process of addressing that insubordination lah. Okay. Next. Oh, we're going back to that previous question. So can a probationer be put on a PIP? Okay, so I think I already answered this question lah. So probation period is actually enough. Yes, if you document it properly with appraisal forms, there is no need to conduct a PIP. But if you want to, there is no harm. After confirmation, example, after 4 months, or we only realize that this person cannot perform on a certain topic, should we continue the PIP? I mean, when it comes to PIP, you just whatever that period has stated inside the PIP, you need to comply with it lah. You cannot prematurely dismiss or terminate the employee before the PIP, or even assess the employee before the PIP period ends. Okay. Okay, so after the PIP completed, we still cannot up to the company standard. Can a company terminate? Yes, of course. Again, if you complied with the proper principles. So what is the legal impact? Because after confirm, we enter a PIP program and terminate. Is it too drastic of a decision? Again, it can be situations where after you confirm an employee, uh, they may relapse in their performance. Okay, maybe they just performing during the probation period for the sake of being confirmed. But of course, if there is nothing stopping the company, or especially if it's written in company policy to say that they cannot initiate PIP after confirmation. Okay, it's always possible. It's just that again, we need to genuinely formulate the PIP lah. Okay. Okay, moving on to the next question by Sebastian. So my understanding is that 3 warning letters and then we can take proper action. What is the PIP process and time frame? I think I already mentioned earlier again, Sebastian. These 3 warning letters really depends on, when it comes to the law, we really only have to issue out 1 warning letter when we kickstart the process. Okay, this warning letter would include the PIP item, the PIP form or PIP plan that has been either discussed or formulated by the manager. And whether or not the company chooses to issue out 3 warning letters or even subsequent warning letters in the in the subsequent months regarding performance issues, especially if there is no improvement in the first 1 to 2 months, then that is of course up to company process lah. But if we're talking about legal obligation to issue out, not necessary, but maybe it can help, especially if it contains certain items that talk about what hasn't been improved on, or what hasn't been achieved. And of course, it must be supported with documentation lah, and also that conversation between the employer and the employee. Okay. Okay, so how to gauge if PIP is reasonable? Will there be grounds to sue if a staff feels that we are using PIP to force resignation? If the staff deem the PIP targets are unreasonable, do we get a chance to justify? So, again, I think I already covered this as well. How a PIP is reasonable really depends on the nature of what they are supposed to do, their core responsibilities, certain conditions to take into consideration, because sometimes their PIP items might not be there might be something that's out of their control. Okay, so that's all the factors you need to take into consideration when you're plotting your PIP items. Okay, of course, definitely, if you don't draft the PIP properly with unreasonable goals, it can be a ground for them to file for constructive dismissal, as we've seen in those cases. Whether or not it's deemed as forced resignation, not so much, because forced resignation is a bit different from constructive dismissal. Forced resignation would be situations where the manager or even HR actively tells the employee to resign because they can't do their job, or even prepare a resignation letter for them, or even threaten to terminate them. So it's a little bit different in this situation. And do we get a chance to justify? I mean, when a constructive dismissal claim comes in due to maybe unfair PIP, you have the chance to reply to the resignation letter of the employee containing all of those allegations of unreasonable PIP. So usually I would recommend a prompt response in basically denying the claims that the PIP is unreasonable. But there have been situations where I see companies delay for very long in not responding, and that is something that may act to the detriment of the company lah. Because when we're talking about delay, usually the court also will look into how long there was a delay in responding to the resignation, the constructive dismissal resignation letter. So always good to respond immediately and promptly, containing all the reasons why you are saying that the reasons provided by the employee is not justifiable lah. Okay. Next. Should PIP be detailed or simple and straightforward? Okay. PIP having 10 items, every support action listed, or 4 KPI targets as PIP, and that's all the measurement, again by Sebastian. So it's always good for it to be more detailed rather than simple and straightforward, as long as we follow the SMART principles. Again, going back to the SMART principles. But of course, when it comes to coaching, support, specifying all of those, that should be something that is actively done and actually carried out and executed during the PIP period, because there have been cases in the past where the PIPs did state that, oh, we will give you training or give you coaching, but the company actually didn't do any of that. So again, you can have the most perfect PIP, the most specific PIP, the best PIP, but if the company actually doesn't see through whatever that they have already agreed upon or promised to do in the PIP, then essentially it's still a defective PIP. Okay, and the employee does have the right to lodge a complaint if they fail that PIP and they're terminated for it. Okay. Okay, moving on to next one. What can we do if after first PIP session of poor performance, the candidate improves and PIP is closed? Thereafter, 6 months later, the performance is declined. Yes, I mean, to answer this question, yes, we have to initiate another PIP lah. Okay. Moving on to the next question. Okay. Condition: the candidate doesn't want to sign off initial PIP form nor attendance, summarize and send details via email coming to first session review after 1 month. What if candidate doesn't prepare the listed progression summary that we wish to have? I mean, again, this can be seen as non-compliance, basically non-cooperation when it comes to cooperating with the PIP process. Again, it can lead to insubordination actions, disciplinary measures. But again, like I've always been repeatedly saying, make sure that the PIP is okay first. Okay. Next question. So what if the line manager doesn't communicate with the non-performer and HR has to be the middleman and end up the manager always finds fault? What if the HR has to be a middleman and end up the line manager always finds fault with the non-performer, so he doesn't want to conclude after several meetings and discussions that happen? Okay, so in this kind of situation, uh, I mean, I've seen it before. Basically, managers pushing the responsibility to HRs to take cognizance over the IP process lah. This is the wrong way to do it. You should inform the managers that, especially if you have a company policy that clearly states that ownership should be taken by the line manager. If the line manager doesn't do anything about it, technically it can lead to a misconduct situation, because they are responsible for managing these employees. And if they don't manage these employees, again, it can be a situation where, for example, if you have reminded the line manager and they still don't want to take ownership of over the non-performer, then it can lead to condonation also. So important thing to note here is that managers are also not immune to these kind of processes like disciplinary processes. So they need to back up and basically take ownership over that, because I mean, essentially they are the people who are managing those employees lah, so they will know better. Okay, so to address these situations, HR, you can issue a show cause letter as to why they don't want to do that, because it's in a way also non-compliance to company policy. Okay, moving on to the next one. Okay, so if we set an PIP on confirmed employees and he or she tendered resignation, do we need to continue the PIP, as we need to ensure that all pending products and assignments needed to be handover as per expected timeline? Yes, they can tender resignation during the PIP period. And there hasn't been a situation that I've seen where companies do not accept this lah. It will happen, and it can happen. The position of the law is that employees are always allowed to tender resignation, be it for whatever reason. But of course, when we accept the resignation as a formality kind of notification letter, you can stipulate that the reason for resignation would be due to non-performance. However, the company in goodwill accepts the resignation, and of course, the resignation letter would have all the necessary details, telling the employee that they should hand over the pending projects properly before their last date of notice, and so on and so forth. Okay. I mean, there is this principle, what we call as safe face lah, which happens very often. Okay. Is it necessary to issue? Okay, moving on. Next question: is it necessary to issue a warning letter during PIP sessions if the employee fails to meet expected performance? Again, I think I've answered this question. Not necessary, but if it's in accordance to company policy, to address situations where throughout the month you don't see any improvement, it is just to notify the employee that, hey, please back up, and just please observe and see, and to reevaluate and reflect your progress with against the PIP lah. Okay. Next, if the employee putting down in the PIP form that she is not agreeable to the priorities set to the PIP form which he or she needs to achieve, what should we do despite the priorities were discussed with the employees? I mean, again, you cannot stop the employees from putting that kind of wording in the PIP, like I mentioned earlier. It can be a situation that employee follows under protest, but ultimately, it would be up to the employee to file the case. We cannot stop. You may, I mean, as an employee, you would have to be able to do your best to ensure that all your bases are covered, all the documentation is there, and the necessary evidence is there to show that you've done your part. But again, although you've done all the necessary, it doesn't necessarily mean that the employee will not file a case against you. The right to file has always been with the employee. Yes, you may think it's unfair, but in order to tackle those kind of situations in the future, that is really something that you have to be prepared for as employers lah. Okay. Next. What if manager slash HOD sets too many targets as KPI to achieve? Okay, when it comes to what can amount to PIP items, right, always good to stick to what has been assessed to begin with. Okay, set too many targets here really depends on what is the role and job function of this employee. I mean, I've not seen a job function where the employee has to do so many things lah, because more often than not, it's related to the core responsibilities, and it really boils down to the appraisal and what is happening throughout the appraisal period that would lead to this many target KPIs to be set lah. Okay. I mean, there isn't case law to say that how many targets you can set, but it must always correlate back to what are the core responsibilities. Okay. Uh, I mean, if we were to talk about, yeah, I think that's always the main key here lah. Okay. Moving on. So if the PIP is issued for every routine task that's done on a daily basis, can we shorten the PIP period? Say maybe 1 month. Ask staff. Okay, so this is concerning whether or not PIP should be for a lesser period of 3 months. Okay. Technically can. Like I said, there isn't case law to specifically say that it must be 3 months or even more than that. What is important is that whatever PIP items that you set for that 1 month, can it be achieved within that 1 month? Can it reasonably be achieved by a person who in that same capacity within that 1 month? That is something you need to consider. Okay. If yes, then please go ahead. If not, then maybe it'll be better to see, maybe give it 2 months for results to be seen. Okay. Next. Can the period be shortened for relapse in PIP? Again, I think to answer this question, I have to revert back to my answer in the previous question lah. So basically, please assess whether or not the PIP results something that can be seen within the period of time that you've given. Okay. Next. If sales is not achieved constantly, would it be a PIP or a warning letter? Okay. When it comes to sales not being achieved constantly, it would definitely be a performance issue. So when it comes to performance issue, if you want to kickstart the official process, a warning letter plus PIP should be communicated to the employee. I wouldn't say that you should issue a warning letter immediately. Perhaps one of the ways to address this kind of situation would be through the informal process, which can be through counseling or coaching. And this period is usually and this counseling and coaching is usually for 1 month lah. So it would also stipulate, what are the things to be achieved within the period of time given, and so on and so forth. You're not kickstarting the official PIP, but if really the person is not performing during the counseling and coaching period, then you can kickstart the PIP process and involve HR. Okay. Okay, moving on. May I know if the senior employee not necessary to put on the PIP? Yes. To answer this, yes. But when it comes to documentation to justify that they have not been performing, that's still something the court will look into. If you terminate them without putting them on the PIP, still need to have documentation saying that they didn't meet their performance items lah. But most companies, although they know that they are not obliged to do so, they will still put these senior employees on PIP, and it must be genuine. Again, go back to the principle of that it must be genuine. Okay. 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 Okay, so sorry, just to address Rina's queries in the chat, right? When it comes to what amounts to a senior employee, I think to just answer this kind of doubt, what amounts to senior employee has not been specifically addressed by the court, but more often than not, they have deemed senior employee to be senior if the years of service exceeds a certain amount. For example, very commonly we see more than 8 years, more than 10 years. Then it would usually be in that sense. or it can be situations of a collective experience. So, for example, employee has been working in this role for maybe 10 years, and then they went to a different company in a similar role, and then maybe for 2 years. So the court actually deems that there is a seniority from carried forward from the previous role. Okay, so it's something to bear in mind. PIP should be issued for every role deemed not performing under the current standards, isn't it? Current standards, it shouldn't be immune to any particular position. No, yes, correct. It really depends on performance items, not immune, not subject to position. Okay, next. So we're running out of time, so I need to really fly through these questions a bit. So the employee has been served with a warning letter due to work negligence and company decided to put him on PIP for monitoring. Is this allowed since he has been punished with warning? I mean, if we're talking about work negligence, I would recommend going through the disciplinary process if the negligence is something that's very serious. Um, but if it's something that you want to address through PIP, it should be related to his performance items that are affected by the negligence. Um, and when and like I said, when you kickstart the official PIP process, warning letters must be accompanied together with the PIP plan. Okay, uh, okay. So that I hope that's clear in that sense. Okay. Okay. When a 3-month PIP concludes with a typical time frame of communicating the outcome. Sorry, when is a 3-month PIP concludes? What is the typical time frame for communicating the outcome? Could you share out how factors like the evaluation, submission, management review, and decision making process might impact the communication timeline? Okay, so the court has always been of the position where if you want to communicate the outcome, right, it should always be after the PIP period, not before, because it can be deemed as a premature conclusion or review of the PIP. So there may be situations where your PIP timeframe or the end period might end on a weekend, or a public holiday. Always safe to communicate the outcome after that period. Okay, and certain factors including the submission. I mean, certain factors like this that would cause delay of a review, or even I think this really boils down to how the company regulates its performance review, as performance or PIP review with the employee. Uh, I think certain things to avoid would be, again, like I said, communicating the outcome before the PIP period actually ends lah. Okay. Yeah. Okay. So next. Regards to Tung Yok Leng's case, even though she's 25 years, if she didn't achieve all targets on the fourth review, would it be reasonable ground to terminate then? I mean, I suppose so. The court didn't really go into that sense. But again, if she didn't achieve those targets in the fourth review, I would think that there would be a valid ground for termination. But the thing is, again, it really boils down to the failure and passing rate of the company, and how does it determine whether an employee has failed or passed, and whether or not the company agrees with the company. Sorry, whether or not the court agrees with the company on that passing and failure rate, and what items are used to assess that passing and failure rate. Okay. Okay. Next question. We have a few more. If the staff is underperforming, is it appropriate? I've answered this question quite a few times already. So warning letter and PIP must always be accompanied together lah. Okay. Next. If there is no PIP given, can the employee still be on probation with no confirmation letter given? Yes, in a way, but again, you must still document the employee's progress throughout the probation period through appraisal forms. No necessary official PIP needed. No confirmation letter given, but you should let them know that there is an extension of probation period lah. Because the position of law in Malaysia is that as long as there is no confirmation letter issued out, the probation period is deemed as extended. Okay, but always good to issue out a formal extension letter. Okay. Next question. If PIP If PIP passed due but yet to conclude or inform the employee as the current manager is on sick leave and previous line manager took the role on PIP assessment in the middle of PIP, can this be done? Okay. Um, okay, handing over, change of person assessing PIP assessment. This is a very good question. Okay. Um, I would think you should pause the PIP pending the return of the manager who is actually overseeing the PIP. Why I say this is because it can lead, I mean, it can open room for the employee to contend that there is inconsistent or subjective views in assessing the PIP, and that of course would not be good lah. Okay. Okay, I think we only cover I will cover another three more questions because we are already technically run out of time. So the last three questions would be in accordance to sequence of who sent in the questions first. So I hope that the other questions that are asked afterwards, I hope I will try to address it after the session lah, maybe to contact you guys personally. Okay. Is it necessary to issue a warning letter or show cause letter before we terminate the employee who doesn't pass the PIP? No, not necessary. Again, I think there's a confusion here with regards to show cause letter. Show cause letter is only used for disciplinary proceedings, which is misconduct, whereas when an employee doesn't pass a PIP, you would issue a letter of termination for failure to pass PIP lah. That's the letter that we usually call. That will usually have the outcome of the non-fulfillment of the PIP items. Okay. Second last question. If staff didn't meet the expectation in the second month, shall we inform the staff he will be terminated during third review due to him didn't meet the expectation without issuing a warning letter before? No. Straight answer, no. You shouldn't indicate or tell them that they will be terminated for third review because the third review hasn't been concluded. You have not concluded the PIP and you're prematurely telling the employee that you will fail. This is a big no-no because we are not sure whether or not suddenly the employee will suddenly improve in the third review. Okay, so you cannot prematurely say all these things. Very dangerous to say all these things. So as a HR practitioner or even as a manager, it would be advisable to not do so because you are foreseeing things that, yes, I mean, maybe in your head or maybe it's very usual for people to fail at this point in time. You foresee that you'll fail, but don't say anything. I think the bottom line is just to tell them that, look, things are not looking good. Please improve in your performance. So that would be the more appropriate way to approach it lah. Okay. Next and last question. So what happens instead of accepting the resignation of employee when employee fails PIP? Instead, the company out of goodwill will be due to long-serving grant MSS. Okay, MSS, it really depends. I mean, there's nothing wrong with this approach. You can give an MSS, but it really ultimately depends on whether or not the employee accepts it because MSS is something that is of a must be mutually agreed upon and technically can be given before a PIP is initiated if there is a chance where you can see that the employee might not pass. But this then again boils down to company culture and perception. I've known some companies that don't really want to do this as a practice, but if you want to, then and if the employee is okay with it, then by all means go ahead because that approach is the approach with the least risk lah. Okay. All right. Okay. Thank you so much, everyone. I know there's a few more questions, but perhaps I'll take that offline. And thank you so much once again for joining us. And also, again, please be reminded that we are having that public course. We're holding that public course. So please, if you are a HR practitioner looking to improve on your skills, to be informed of the latest developments of the law when it comes to termination and how do you handle it practically, please, join this public course. I trust it will be very insightful for you guys, and more so because a lot of practical approaches will be discussed during the session. And Yeah, so please feel free to join. This is the KL one at Sheraton Petaling Jaya Hotel, and then we have another one in JB and Penang, which would be on 16 and 17 July, on the same date but in different locations. And I trust that these public courses will be very beneficial to you guys lah. Okay, all right. Thank you, everyone. Have a good evening. Now it's already evening. It's reaching to evening. Please please feel free to reach out to us if you have any queries, and also if you have any are interested in our services, also please feel free to reach out lah. Thank you very much for your time. Take care.